So today is the final day. It actually roll over into day 6.
Yes.
And to just provide a recap of all the submissions made and the discussions happening over the past 5 days.
Wow, it will require great memory to do all of that. But certainly the defense is saying no retrial. The prosecution is saying there can be a retrial. There was a breach of the fair trial right, which was the central issue of this case, and whether or not the court can order retrial in the circumstances. Certainly for the defense, we would have presented affidavit evidence, which was a plethora of documents. As you can see, it went over into day 6, and even at the end of day 6, there were so many documents that the court was inundated with information that they now have to go through. I just wish to make clear that because of this, it is one of the reasons why the court now has to go through the information and have a written judgment, because this is a high public interest matter, and so the explanations coming from the court will be of great value.
Something in your submissions that you made that I heard you present was saying, they were suggesting the prevalence of these kind of murder cases. Another thing that you had mentioned, breach of constitutional rights, and also public interests. Do you think those in that submission, do you think it holds any weight, or will it affect any decision made?
In terms of the prevalence of the offense, the prevalent Jamaica is a high crime society. It's recognized. There is resource in terms of information that puts Jamaica as a high crime society. I think what we need to appreciate is that when it comes to constitutional rights, it shouldn't be taken lightly. And so if we're to give effect to the rights, it has to be on a spectrum. So while it is, I'll just say, the prevalence of the offense, it has to be weighed with the presumption of innocence. The circumstances of the court resources, the length, all of these are things that when it comes to the interest of justice. For instance, we have at least 744 cases this term alone at the Supreme Court where these persons either need to be on bail or want their matter pushed forward. If the court has to push back, those persons are going to be in a position where they'll be crying to the court about delay. We have many issues within our justice system. We're not perfect, we're a developing country, but what this case shows is that we can, from the defense bar, that's the Bar Association, the prosecution sides, and the judiciary, give advice to the legislators in terms of how to put in statutory safeguards to ensure that certainly for a retrial like in England, the limit is 2 months, and we've gone beyond that.
Let me get 2 months. Can I ask you what's the if you spoke to your client and what is feeling and the progress of the case?
Certainly, in terms of the progress of the case, the client is anxious. There's not much you can tell a man who wants to get out of jail as to why is it being delayed or anything like that. It is a continuing breach, and that, as I said, that's certainly where it is. And so I have no comforting words for my clients, save and to say that the court has now made it clear that they're mindful of Mr. Palmer's illness, they're mindful of the length, and that certainly they have given a time, as in the maximum time that they will be able to write the judgment and be able to hand it down.
As you mentioned before, and the judge had alluded to a lot of cases, as I mentioned, 700 that are awaiting response in the system. Do you think that this case can be pushed, will be pushed back, will be affected by the delays and all of that?
This case? Yeah. I don't even know to respond to that. My response is always God on time. This case is finished. I from the defense bar, fresh justice is something that a concept that we ought to be looking at in terms of trying to ensure that persons who are put before the court for the very first time, that their matters don't fall into the position that the appellants are in this particular case. So in terms of pushback, the judge did make it clear that there will be some pushback for other cases to ensure that in light of Mr. Palmer's illness, that they get the judgment out at the fastest possible time. And the blame is now at the hands of the prosecution and the defense, because we inundated them with paperwork, which was my defense is it was necessary to do so.
Are you confident in what the ruling will be?
I'm always confident. I'm always confident. It's God on time. I only speak positive to the universe.
Anything else you want the public to know?
We are at a time where constitutional amendments are being spoken about. It is your right to know your rights. The Constitution is the only safeguard against your interests and government. Don't lie carelessly and take it for granted, because it could be you.
You mentioned something earlier about not you specifically, but that the charter should not be empty promises. Do you understand on that here?
Well, if it says you have a right to life, it is a promise that the charter is saying that right will be protected. And if unfortunately it is that you have lost your life, how it is that if it's by the state, how the state guards it, how the state gives effect to it. Same thing, your freedom of expression. The media has a right, which is why the court has made provisions so the media could come and observe, so that they can disseminate information. These are promises to the Jamaican people, to the citizens, and if these promises are to be kept, it is only the court that can give effect to it, because state actors will breach it. Your citizens, the Constitution makes provision under Section 13(5) that horizontally a citizen can breach your right. It is the court that you go to say my right is being breached. When I made mention of the lady Whistledown situation, Sir P, Miss P, Lady Whistledown, they could probably all be the same. I don't know. But the danger of that is they are allowed to defame you. They are allowed to cast aspersions on your character. They are allowed to say anything, and the court is unable to regulate situations like that. So if the rights are to give effect, there must be some remedy to protect you, even from...
Alessandra Beach, attorney at law for the first and second appellants, Sean Campbell and Aditya Palmer. We are happy that the information is now before the court for them to give their mature consideration. We admit to have inundated the court with a plethora of documents, volumes, and so we know that they would need time to take all of that into consideration. There are lots of reports, a lot of affidavits. We believe that we put forward all that was necessary to establish our client's case and their wish to not be retried in this matter. Well, that's the thing. It has to be considered in the round. So there are lots of factors that we have to take into consideration. It's really a balancing exercise, and what weight is given to each of the factors separately and cumulatively is a matter for them now, given the evidence that is before them. The length of time, the seriousness of the offense, and the constitutional issues which we hope and which we urge to be brought to the forefront, given that our system espouses constitutional supremacy. So we urge the court to start with the constitutional considerations. Well, in all matters where a retrial is ordered, they would treat it expeditiously. That is the general principle. We cannot say what caused the delay in the two matters that you have mentioned, which are the Hamilton and Taft matters. We hope that, and we know that the courts will take these things into consideration when they are deciding whether or not this matter should go for a retrial, given the status of those matters that have already been sent to retrial and how they have been advancing through the court system and the pace at which they have. As you note, no trial date has been set. For one of them, a bail application is upcoming, and that is just now after some time has passed. So those are considerations for the court to grapple with when they consider whether or not it would be in the interest of justice to order a retrial in this case.